Good morning, everyone. Well, first, a very big thank you for joining us for this panel discussion on the benefits and disadvantages of mediation on the one hand versus arbitration and litigation on the other in the context of the resolution of commercial disputes. I'm Caroline Pounds, KC, a barrister here at Quadrant Chambers, practicing in general commercial litigation and arbitration, with a particular focus on shipping and energy matters. The vast majority of the disputes that I deal with are heard in arbitration rather than in court, with a significant number of those going through a mediation somewhere along the way. The good news is you're not going to be hearing too much from me today, as I have the very pleasant job of introducing our speakers and moderating the discussion. Now, the aim is for this to be an interactive discussion, hopefully involving you as the audience as well as our speakers. And what we're going to be focusing on is comparing and contrasting different experiences in the UK and India. Our fourth speaker is Sidharth Sethi. Sidharth is an advocate on record at the Supreme Court of India and a disputes partner at JSA Advocates and Solicitors, one of India's leading full-service law firms. His practice spans complex corporate and commercial litigation, arbitration, and alternative dispute resolution, and he is a recipient of numerous Indian leading lawyer awards. Somehow, despite that very busy and successful practice, Sidharth also finds time to teach company law and alternative dispute resolution as a guest faculty at a leading Indian law school. So we have a panel with a wealth of experience. Let's hear what they have to say. Why don't we move to Sidharth? And perhaps, Sidharth, in light of what Mark said, maybe we should go back in time. Perhaps you could begin by giving us a historical perspective of how mediation has been viewed in India and how and to what extent that's changing in light of recent developments.
Thank you, Caroline. Esteemed members on the panel, ladies and gentlemen, namaste and a very good afternoon to all of you. The short answer to the question, Caroline, is that mediation is not a new concept in India. But before I give an insight on that, I must tell you that commercial dispute resolution in India today is dominated by arbitration, at least in the marquee disputes that we have. And over the last 2 decades, India has invested substantial effort in legislative and judicial decisions to make India an arbitration-friendly jurisdiction. That said, modern commercial landscape is changing, and businesses today are not merely interested in getting a decision. They are looking beyond that. They want quicker resolution, lower costs, confidentiality, and most importantly, preservation of future cooperation. And therefore, alongside arbitration, mediation in India is emerging as a very important pillar of dispute resolution and I would say a more commercially sensible pillar of dispute resolution. And the real question in India today is not whether we should go for arbitration or mediation. The question is which method is best suited to resolve the dispute to preserve future business cooperation and business value. But taking you back in history, it is not a new concept. It is deeply aligned with India's traditional and cultural approach to conflict resolution. My friends here from India and those who joined us online will know that Bhagwan Sri Krishna actually tried to mediate the dispute between the Kauravas and the Pandavas. And he actually went to Hastinapur. And this is very beautifully summarized in a poem that we have by one of our leading poets, Ramdhari Singh Ji Dinkar, where he says, and Krishna Bhagwan, when he goes to the Kauravas, he speaks to Duryodhan and he says, Do nyay agar to आधा दो, दो न्याय अगर तो आधा दो और इसमें भी यदि बाधा हो तो दे दो केवल 5 ग्राम, रख लो अपनी धरती तमाम. Which basically means that he told them that you can give half the empire to them, that will maintain family peace, your cousins after all. And if that is also not feasible, give them 5 villages. They'll be content with that. Duryodhana said, no, I won't do that. And then the rest is history. We know what happened. There was destruction. And this is also very beautifully captured in Ramdhari Singh Dinkar ji's Kavita, where he says, जब नाश मनुज पर छाता है पहले विवेक मर जाता है, which again I'll translate for you, that when you're not thinking in your right mind, then wisdom takes a back seat and there is destruction. So yes, much before the modern day mediation that we have, India has seen it is deeply aligned and it is a part of our culture. The traditional panchayat system has always prevailed in India. Community issues were resolved by a group of village elders in the olden times. They were called the Panch Parameshwar, the five sensible men in the villages. Disputes were also referred to businessmen called the Mahajans for resolution of disputes amongst the communities, amongst the contesting parties. And so modern mediation that we have today simply institutionalizes principles that have long existed in our tradition and culture. And there has been a formal integration of that in the post-British era. In 1947, we had the Industrial Disputes Act, which provided for resolution of disputes outside the court. Subsequently, we had the Legal Services Authorities Act in 1987, which provided for the establishment of lok adalats, again for resolution of disputes in an amicable manner. And I believe the numbers which Mark just shared with us, I don't think those capture the lok adalat resolution numbers, because lok adalats are all over the country. And then commercial mediation saw statutory flavor by introduction of a section in our Code of Civil Procedure 1908, which is section 89. Then we had something in 2015, the Commercial Courts Act, which mandated pre-litigation mediation unless you were seeking some urgent interim relief. And most recently, we've had the Mediation Act of 2023, which is the most significant development in the mediation landscape in India. It does some interesting things. It formally recognizes mediation as a form of dispute resolution. It provides enforceability to mediated settlement agreements, promotes institutional mediation, recognizes online mediation, and it enhances confidence amongst domestic and international businesses. So this is a bit of a historical background and how we've come, but yes, there is a long road to be traveled. I'm not saying we are perfect there, but I'll throw some light on those numbers also maybe a little later, Caroline.
And you mentioned the 2023 Act, and you've also mentioned to me previously something called the ARB model. What can you tell us about that?
Yes. So the ARB model is one of the recent and significant developments in the mediation landscape, evolved institutionally in Singapore and administered by the Singapore International Arbitration Center and the Singapore International Mediation Center. Both Prashanto and I happen to be specialist mediators with the SIMC. And this model is a hybrid dispute resolution mechanism. It gives you the flexibility of mediation with the certainty of arbitration. So when you commence an arbitration, at any stage, at a mutually agreeable time, you can pause the arbitration proceeding. Parties can then try and see if the dispute can be mediated, and if there can be a mediated settlement. If it succeeds, very well, parties get into a consent award, which is enforceable, and if it fails, you get back into that arbitration mode. India does not have a codified ARB-Med-ARB model. However, it gets structural support from our Arbitration and Conciliation Act. We have a few provisions in our existing legislation of 1996 which gives structural support to this hybrid mechanism also, though not called like this. So we have a section 30 in the Indian Arbitration and Conciliation Act where an arbitrator can encourage parties to settle the dispute, and the settlement can then be passed as a consent award, which is provided in section 31. The arbitrator can use different modes, can be mediation, can be conciliation, or you call it by any other way, where parties are able to settle the dispute. Then section 73 speaks about conciliation. So yes, our MEDA model is there in our legislation, though not codified, not called by that name as we have in Singapore, but we do have traces of it.
We heard from Mark that from an English perspective, he's obviously a big fan of mediation, has lots of experience of it being successful. We had some pretty very low-sounding statistics, but pre-action, yes. And now, what I'd be interested in your practical experience, and to what extent now are you experiencing in India concrete examples of mediation resulting in a successful outcome for the parties in commercial disputes?
So yes, Caroline, while mediation and arbitration are both forms of alternative dispute resolution, they're fundamentally different. In arbitration, the central question is who is legally right. But in mediation, a lot of focus goes into understanding the underlying commercial relationships, because the idea is to arrive at a mutually acceptable solution. So the central question in mediation then becomes what solution works best for the parties to preserve future cooperation. I am quite optimistic. Of course, numbers which Mark has shared are official numbers. But as I said, modern businesses today work through long-term commercial arrangements. There are disputes between manufacturers and suppliers, joint venture partners, customers, and service providers. So in arbitration, you can get a binding award, but it really preserves trust. It really restores trust. On the other hand, in mediation, and that's something we are seeing greatly in India now, you are able to preserve that future cooperation. And therefore, from an Indian standpoint, and which is true from, I believe, other jurisdictions also, mediations are proving to be successful. I will share some other examples from some of the matters I've done in the last 3 or 4 years, where I've been able to get results which I would not have otherwise been able to get for my clients in an adversarial proceeding. From an Indian standpoint, mediations are proving to be very cost effective. Businesses would rather spend that time and energy on commercial growth than on dispute management. Confidentiality is one big aspect. No party today wants their disputes, documents, and strategies to be exposed in public view, so mediation helps them preserve that. Preservation of relationships, they are able to come out with creative solutions. They are able to design the outcome themselves. An arbitrator will impose a decision on them. But in mediation, a facilitative mediation, they are able to decide for themselves what works best for them. And you asked me about some examples, some concrete examples. The government had introduced certain guidelines few years back, and we've all spoken about those guidelines in the public sector, in relation to public sector undertakings, where states are involved in contracts, that disputes lesser than 10 crores should be promoted and resolved via mediation. We all looked at the arbitration aspect, and there was a lot of critique that India is going 2 steps forward and then 2 steps backward, and that's not working out. But one important message in that guideline was that Indian government wanted to promote mediation, and I'll tell you why. The government, the Ministry of Finance, had introduced a scheme known as the Vishwas se Vivad se Vishwas tak, which invited parties to come and try and resolve the disputes. And in a very short span of time, the government received more than 900 claims, if I get the numbers correct, disputes worth 20,000 crore Indian rupees, and a very short span of time, almost 2,000 crore worth disputes were resolved by mediation. Future cooperation maintained, those companies continue to work with the government, and that perhaps propelled and encouraged the government to maybe come up with these guidelines, and then the Mediation Act also in 2003.
But it's not just preserving relationships. Sometimes parties hate each other by the time you've got a dispute. It's also speed, cost, and from the government perspective, clearing the backlog, isn't it?
Yes, absolutely. So in those areas as well, it is certainly proving to be a boom. And in the last 1 year, I can give you concrete examples. I will, of course, not be able to name the clients here, but in the last 1 year, 3 international arbitrations, 2 seated in India, and 1 outside of India at various stages. At the Section 9 stage, where the arbitration was about to commence, another arbitration where we had just filed the pleadings, and another one where the evidence had to be filed. We had not filed it as yet. We have been able to encourage the parties to mediate and settle the disputes, and they've been able to do that in a matter of months, and both parties go home happy. At the start of any big dispute that comes to us as a law firm now, we try and do a viability assessment for all our clients. We do a cost benefit analysis for them. It's like sitting with them and doing crystal ball gazing. And we tell them, this is what your dispute is. This is what is going to happen in the next 4 or 5 years. And let's say there is an award. The enforcement will also see some challenges. And do you really want to do this the next 5 years? You may hate the counterparty, but do you really want to do this next 5 years, or do you want some quick resolution today, maybe adjust some positions here and there? And I have seen that my clients have always appreciated that. Always appreciated that.
This is addressed to both of you, that the success or otherwise of the mediation is heavily influenced by the lawyers on the other side. Whether, are there still lawyers, and are you now seeing this less, who will sabotage the mediation, or who will be encouraging a client who wants to sort of fight hard, but rather than talking them down and extolling the benefits of a settlement, even if it's not perfect, but actually sort of geeing them up or purely pouring fuel on the fire? Do you still see that, and is that less than it used to be? And is that a factor that will really influence whether the mediation is successful or not? Or are you seeing clients, even with that kind of lawyer, saying, I don't care, he can be as aggressive, but I want to get this sorted out?
Yeah, so I mean, statistically, I'd say to be able to decide whether whether the lawyers. But I've seen both types. I've seen situations where I'm leading a team, and I turn around to my solicitor and I say that, listen, there's a very good chance of settlement, and why don't you? And he said, absolutely not. I mean, you don't have instructions to settle or do anything like that. And he wanted to continue. And I've seen lawyers, and that makes a difference. Just to answer your question, it makes a difference that one mediation where it was almost coming to an end, and then the party said, one of the parties said, we have to catch a flight, and they stood up and they were going. And then suddenly this party, he said, have they left? I mean, I said, yeah, they're about to leave or whatever. He says, no, if we can just have one last meeting. And I had to reach out to the lawyer and I said, I'm very sorry, but they're catching the flight. But can you please consider just staying back? So he persuaded them. He could have been a lawyer who could have instigated them and said, listen, you're in a good position now, go ahead. Stayed back, and it closed the issue. Just that staying back made a difference. So it was a lawyer's prerogative. Yeah, yes, absolutely.
Right. The way I look at it, lawyers play the most important role when it comes to ensuring that parties are able to settle and mediate. And therefore, when I said it is my job to sit with my client and do a bit of crystal ball gazing, show them what exactly is the merit in their matter. I'll give you a very recent example where we mediated, we entered into a settlement agreement, international commercial arbitration. The settlement agreement has been signed. It has been filed in court. It has become a part of the court record also now. And now, even to give effect to the terms of that settlement, the other side's lawyer is trying to make it a bureaucratic maze. So that, yes, lawyers do play a very important role. And I've also seen with some law firms and some lawyers who are not inclined to settle because they look at it as a way of revenue generation, which is very sad, very unfortunate. The way we look at it, and I tell this to all my colleagues and my junior friends, and as a firm, we guide our colleagues that a client has come to you. Maybe this matter gets resolved, but you're then becoming their relationship manager for the rest of their life. They will come back to you for every other dispute that they have because they have that trust and confidence in you. So you play the role of a counselor there.
We've come to the end of our hour, so I think we need to wrap up. But I would just like to ask each of you, and I think the audience may be grateful for, if you were to give one practical top tip for how to make a mediation effective, what would it be?
Yeah.
Sidharth?
From the standpoint of the clients, and that's a view, maybe slight variance with what Rob mentioned and Mark mentioned, I believe early intervention is very important if you want to see a successful mediation, because once the positions become entrenched, then it becomes very difficult to untangle them.
I think I was in the middle. You and Rob on that. Yeah.
Well, does anybody have any questions?
Thank you very much. My name is Jeffrey Bloom, and I am a ship broker, but also maritime arbitrator, and I've done some mediation too and expert witness work. The question is to you two gentlemen how it works in India. I think I know how it works in this country, namely that you can be appointed, and I am often appointed, precisely because I'm not a lawyer. I come to a dispute because of my commercial background. And the discussion I've heard so far, fascinating as it was, tends to give me perhaps the wrong impression that in India it is mostly mediation arbitration by lawyers, as you would find in court. Is that so? And if so, might another aspect be looked at in India, namely using commercial people who understand the actual problem?
You're absolutely right, Jeffrey. And that's one of the feedback we've already given to the government, that we need more specialized mediators who are sector-specific experts because they understand the business. Not every lawyer will be able to give you a commercial solution. He'll be able to give you a legal solution, but not the commercial solution. If you want to preserve future business value, future cooperation, you need sector-specific experts. So I agree with you. We need that.